Good morning. So we will start in time. This course is intended to improve the legal literacy among our members. In fact, doctors, even though they are very straightforward and they don't do any harm to the patient purposefully, they are at the receiving end many times. And regarding legal proceedings, all of us are little afraid. And this course is intended to help everyone understand the intricacies of law and how we can defend ourselves in the if there is a litigation. So we have myself, I am Dr. Mahesh, working in Kochi as a VR surgeon, and Dr. Anand Vinekar is in Bangalore, again ROP specialist and VR surgeon. Both of us are having a postgraduate diploma in medical law and ethics. Then we have Dr. Ashok Nataraj. He's a VR surgeon in Trivandrum. He has an LLB. So we will be trying to help you with some of the legal pearls that you can practice in your day-to-day life. So over to you, Dr. Ashok Nataraj. He will be speaking on liabilities of medical practitioner, intricacies of Consumer Protection Act, and steps in defending a case successfully. Over to you.
Thank you, Dr. Mahesh. Thank you, AIOS, for giving us this opportunity. So, slides, please. Yeah, so to sum up the whole topic, I've just given law for doctors so that, it mentions whatever Dr. Mahesh has said. So what is medical negligence and why we should talk about medical negligence? Because, when in medicine, when you treat a patient, not everybody gets cured. And what is the main reason for patients not getting cured? It seems mistakes from doctors is the main reason why people don't get cured. That is what some studies have shown, and that is the importance of medical negligence. Now, what is medical negligence? There are three aspects to it. One is there is a duty of care. That is, when a patient comes to you, a doctor has a duty to treat the patient. That is duty of care. And there is a duty of reasonable care. What care you have to give is what a reasonable or an average doctor can give or should give at that point of time. And the third thing is there should be a breach in duty of care. The doctor is not giving the care properly. And because of that breach in duty of care, there should be an injury. So that is when a damage occurs, and that is when you are liable for medical negligence. So when you have medical negligence, it can come under a lot of laws that we will tell later. So mistakes and negligence, so these are the common errors that are supposed, that doctors are supposed to make when medical negligence cases come. Okay. Now, what is standard of care? Now, you have a duty to care. You should know what is standard of care. Standard of care is, it's not that, you should be the best in the field. It's not like a big-time cataract surgeon who will give 6/6 for all patients, but you should be among the average or a normal cataract surgeon of your peer group, and you should deliver that results. That is the meaning of duty of care or standard of care. It doesn't mean excellent standards or superlative standards. It means normal standards that are applicable to everyone. Now, what are the liabilities that a doctor has towards a patient if the medical negligence cases come? So when you have this, you can have liability under different headings. You can have civil liability, criminal liability, liability under tort, disciplinary action, res ipsa liquidator, and all that. So, see, you have done some, there is some wrong that has been done, there is some damage, there is some negligence. You should not think that, they can give case only under the Consumer Protection Act. You should not think that they can case only, patients have multiple options of giving cases against you, and Consumer Protection Act or consumer courts are easier to give, and that's why patients give cases to them. And and disciplinary action means through NMC, they can take action that you have not done properly. And res ipsa liquidator, sometimes the damage is so much, somebody does a surgery, they leave a scissors inside the patient. Now, the damage is obvious, the negligence is obvious. In that particular time, it is not the patient who has to prove negligence, but the doctor who has to say that, why this happened. So the onus of proof falls on the doctor rather than the patient in such situations. Now, the new Consumer Protection Act and the new, the laws have come. Now we have IPC, CRPC, and Indian Evidence Act being replaced by Indian acts. Amit Shah ji has already passed it in the parliament. It has got presidential assent, and the new laws will come in force by July 1st, 2024. So now the Indian penal code is called Bharatiya Nyaya Samhita. Okay. So there was a news that, now doctors are exempt from criminal liability. Now the main situation here is, what is the criminal liability that doctors have? This has been clearly mentioned in that particular case law, Suresh Gupta versus Government of NCT. Like, usually what doctors come under is 304A IPC, that is death due to rash and negligent act. So as far as doctors are concerned, gross negligence should be proved so as to put criminal liability on them. It is not just negligence like any other person, there should be gross negligence. Now, this has been further reinforced in the Jacob Matthew case, where saying that, just being negligent doesn't amount to gross negligence. Gross negligence should be proved by in the presence of an expert, and the court should be convinced. Only then a criminal liability can be put on doctors. Now, what are the safeguards that the laws have against criminal liability against doctors? So, one is gross negligence. It is not just negligence. And second thing is, if it is a private complaint means a patient goes to a judge and say that something has gone wrong, and a judge calls the police or necessary authorities to take a case against whomever has done the offense, or through an FIR through a police. What happens is this gross negligence should be confirmed by a expert doctor or a competent doctor. Only then the police or judge are supposed to carry on with the investigation and take criminal negligence against the doctor. And these things are not applicable to people who are not doctors. So you see, this is some filters we have protecting us from criminal liability. Now, this is the basic thing. Now, the earlier law means till July, it will be Indian Penal Code. And now, after July, it is called Bharatiya Nyaya Samhita. So 304A IPC, under which this negligence comes, is now 106 section of the Bharatiya Nyaya Samhita. According to the Bharatiya Nyaya Samhita, this 304A IPC, where, you get, negligence or criminal liability, the punishment is 5 years imprisonment. Earlier, it was 2 years imprisonment according to IPC 304A, but now the punishment for 304A violation is now increased to 5 years. And this criminal liability is applicable to all medical practice, all medical practitioners recognized by the NMC of 2019. This criminal liability is applicable to them. So for a registered medical practitioner, according to the new law, for a normal person it's 5 years. According to the new law, for a registered medical practitioner, this imprisonment has been reduced to 2 years, which was in the earlier 304A IPC, it was 2 years. Now in the new Bharatiya Nyaya Samhita, this criminal liability under 304A IPC has been increased to 5 years of imprisonment. But for doctors, this 5 years has been reduced to 2 years in the Bharatiya Nyaya Samhita. So that is the only leniency that doctors have got. It is not that, according to the new law, doctors are exempt from criminal liability, and there is a mandatory fine also along with that, along with this punishment. So these are the liabilities. 304A means death due to rash and negligent act. 337, 338 means grievous hurt or hurt due to rash and negligent acts. And these are the defenses. One thing you should always remember is, just because you have taken a consent from the patient, it doesn't mean that you are exempt from any liability. Consent, good faith, all these things are only defenses that you can put forward when a case comes against you. It is not that since patient has consented, he has consented to your being negligent. That is not true. So this is, and always courts have favored, in a way, doctors only, saying that, a perfect result cannot be always got in a particular disease, and doctors are not gods. So it is like a reasonable care, and there should be, there should not be any negligence. That's all the court will look into. And this is what I said: redressal, civil and criminal courts, and Consumer Protection Act, NMC, and permanent log adalat also you can give. Say there's something called this permanent log adalat, Consumer Protection Act. All these things are quasi-judicial bodies. Importance of quasi-judicial bodies is, if you're going through the normal route, it takes a long time. These quasi-judicial bodies are there for speedy redressal of problems of the consumers. So this permanent log adalat means it pertains to cases in public utility services, and compensation up to 1 crore can be awarded by the permanent log adalat. So they can even give a case in the permanent log adalat. But usually they give a case in the consumer protection courts because of many reasons. I'll just tell you. And the famous IMA versus VP Sharda case, medical profession has been brought under the Consumer Protection Act, and the Consumer Protection Act of 2019 covers medical negligence. See, initially there was a confusion that in 2019 CPA, medical negligence is not mentioned. Usually when a law has to exempt something, it has to be explicitly be mentioned that these things don't come under the ambit of law. If it is not mentioned, it doesn't mean that it doesn't come under the ambit of this CPA. So at present, medical negligence comes under the CPA or Consumer Protection Act of 2019, and it covers medical negligence. Now, the liabilities, now if you look at the Consumer Protection Act, you have three levels. One is the District Commission, next is the State Commission, and another one is the National Commission. There is something called the pecuniary jurisdiction. How much of liability that the doctor has to pay or whatever, depending on that, the cases can go either to the District Commission or the State Commission or National Commission. You know that up to 50 lakhs, District, up to 2 crores, State, and more than 2 crores is the National Commission. Now, what are the nuances of the Consumer Protection Act? See, if Consumer Protection Act of 2019, there are a lot of pitfalls which actually goes against the doctors. Initially, IMA and all that, when they were fighting cases, they used to say that, medical negligence doesn't come under the Consumer Protection Act of 2019. But now it has been clarified, and I know, like, it is also a service. Like, you gives a service to the patient, and patient pays you money. So it comes under service of the Consumer Protection Act. So doctors are in the ambit of the Consumer Protection Act of 2019. Then the second important thing is limitation period. There is something called as cause of action. Cause of action means the time at which the reason for the injury actually started. So whenever a consumer has to give a case, it has to be done, as far as medical negligence, it will be done within 3 years of the cause of action. But usually it is not the case, because if the court is convinced that this person could not give a case because of various reasons within that particular period, then the court will allow. So it's very important that you keep your documents. They can give a case even after 10 years or 15 years if the court allows and sees appropriate. So that is very important. And the third thing is, it is discretion of the judges. Judges are all human beings. And as you know, consumer courts are for the consumers. It is not for the doctors. So they will always favor consumers as far as these things are concerned. Now, another thing is, you have to file a reply within 30 days and maximum up to 45 days. If it goes beyond that, then you don't have a chance to fight against, or it should be, the case will be decided ex parte. Ex parte means the court will decide the case without hearing your part of the controversy. Then another nuance here is, if there is an award, and if you have to go to the next level, appeals are possible only after you pay 50% of the awarded amount. Initially, it was not like that. And the third thing is, now the filing has become very simple. You can file online also anywhere in India. Suppose in Calcutta, you treat a patient from Chennai, and he gives a case he can give a case against you, not here, he can give a case against you in Chennai Consumer Court. So you have to go to Chennai every time to fight the case. So that is also something. And the main thing is, just to file a case in the Consumer Protection Courts, the court fee is very less. If you have a claim of more than 2 crore, you have to just pay 5,000 rupees as court fee. That is enough to give a case against you. So that is why everyone runs to the Consumer Protection Act, because if in the civil court you have to pay 10% of the damages. Like, that will be a huge amount that the complainant has to pay. But here the fee is very less, and that's why they give cases against us in the Consumer Protection Courts. Now we have all the schemes like professional protection scheme, professional indemnity scheme. The professional protection scheme is run by the IMA. It is a protection scheme. See, indemnity scheme is, it's just like an insurance. Like, they'll say, okay, if you have a case, we'll give you this much money. And within that money, you have to find your lawyer, you have to fight your case. But professional protection scheme of IMA is not like that. Here what happens is, like, they give you lawyer support, they give you professional advice, and here it is for justice and not for settlement. See, if they find that, like, if you want to go for an appeal, they will fight for that also. You can go up to the Supreme Court. If they find that a small compensation has been awarded, but justice is not served, means they will again fight the case. They will not try to settle it. But in professional indemnity, it is not like that. They will try to settle it at the lowest amount and leave it. And this professional indemnity schemes usually don't cover criminal cases. In the professional protection scheme, it covers even criminal cases also. So I should urge everyone to be a part of the professional protection scheme of the IMA. It is available for individual doctors and even for hospitals. And for a claim up to 1 crore, the premium per year is maybe 10,000 or 12,000. So it is not very, very high amount. And because it's a doctor's organization, settlements are very prompt and easy. And these are the defenses that a doctor can put forward, like known complications, difference of opinion, these are all things, I mean, these are not, blanket protection, but these are all defenses that the doctor can put in case he has got a negligence case. So this is one thing, and I'll just tell you about what happens actually in a medical negligence. Suppose a patient feels you have been, you have not been treated properly. The doctor has been negligent. First thing is he'll send you a legal notice saying that, if you don't pay me this much money within this much amount, I'll be forced to go to the court, etc., etc. Now, the important thing is you should reply to that legal notice through a lawyer. Many a time, if you give a very, very good reply, that case gets settled there and there itself. You should not say that I don't agree, you get lost. No, that is not the reply. With facts and all the other things, you should give a reply, because not giving a legal reply means it is bad for you when the case goes to court. Second thing is, now you have replied to the legal notice, and the patient wants to go against you. He will approach the consumer forum. Now, the consumer forum will look at the merits of the case, and if they take up the case, they will send you something called as a summons. It will come to you by post. Now, you have to read the summons, and you have to give a reply within 30 days. And maximum up to 45 days are given to the doctor to reply. Suppose, you don't give a reply within 45 days, you lose your chance to reply. Your part will not be heard. So the most important thing is, as far as lawyers are concerned, they are not bothered. They don't have time for you. So it is up to you to run behind them and give the reply. Now, once you give the reply, there is something called as, they will give a reply to that, refuting your claims. And the case will go to the court. There will be hearings. There will be evidence, inquisitories, etc., etc. And there will be a final hearing when everything will be heard and the judgment will be passed. One important thing in the National Commission, which is different from our other places, is that, in National Commission, everything is like online. It is all written only. They don't the doctors don't have to go to the court for, evidence giving or cross-examination. Nothing like that happens. Everything is through writing and only documents. And maybe for the final hearing, you can go and just sit there, but the actual cross-examination that occurs in a case, that doesn't occur as far as the National Commission is concerned. So I think time is, how much time do you have? 5 more minutes. You can get the next presentation. Now, this is one important topic. This is called as doctor-lawyer interaction in a medico-legal case. So, this is what is happening. Now, first thing you should understand is lawyers don't come under the Consumer Protection Act. Just because the lawyer has not run your case properly, you cannot give a consumer protection case against him. They are not like you. So, it is very important that you should go behind them if you want to get your case sorted out. Okay. So, the most important thing is be vigilant, don't be dormant. This is the Latin saying, vigilantibus non dormantibus. It means be vigilant, don't be dormant. So, basic thing is you try to avoid an interaction with a lawyer. That is the basic thing. So, you take all precautions to avoid a medico-legal case, and the most important thing is proper communication. Then this is what I told you about legal notice. This is what a legal notice means. Now, after this thing, see, what happens usually, you will go to the lawyer who's most friendly to you. That lawyer's daughter would have had a foreign body in the eye. He will call you at 11 o'clock in the night. Then you will say, you bring her immediately, I will see her. And you will see. And when you get a legal notice, you will call the lawyer at around 10 o'clock. Then the lawyer will say, doctor, actually, I don't have time right now. You call me at 9 o'clock in the evening. Then we will talk. Then your heart will break because you have been so much kind to him. He has come, you have, obliged to him all the time, but he is talking like that. But you should not think like that, because that is how lawyers work. And the most important thing is, in the initial thing only, you should get the best lawyer. What happens is, when it goes for an appeal, appeal is is decided on the matter of law and not on the matter of fact. Whatever you have not filed in the beginning, or whatever arguments you have not kept in the beginning, you cannot bring in a new thing for the appeal. So most important thing is, the first time only should be the best shot. First shot should be the best shot, and this principle is called constructive res judicata. And another important thing is, lawyers don't know anything about medicine. So you have to sit and teach, and whatever reply, you only have to sit and write. And you give it to the lawyer, he will convert to the legal form. You should not think that it is like doctors, they come and sit in front of you, you have to do everything. As far as a medico-legal case is concerned, and as a doctor, you should do all the work, and the lawyer is only a medium to represent you in court. Okay, this is Krishnamar case, ROP screening. Actually, at that point of time, there was no ROP protocol at all. And it is said that such a big award for ROP was given just because he was not properly represented in the first time. And a detailed reply, take your time. And be very emotional, don't be objective, and discuss with your lawyer, do everything properly. And another important thing is lawyers are always busy. Whenever you have a doubt, you'll call the lawyer, he'll not pick up the phone. So in the lawyer office, there will be one person who is jobless, whom you can have access. You catch hold of him and maintain a communication with him so that, whatever you want to convey, you can convey through him. That is one important point. Then a response within 30 days, these are all laws, relevant documents, attend, and important thing is you should attend all hearings on time. Because after 3 hearings, if you don't go, arrest warrant will come to your house. They'll force your attendance. And if you don't go the first time and you go the second time, what usually the judge will do is he will ask you to stand there. And your case will be called last as a punishment for not coming in the previous time. So most important thing is, whenever a summons you get to the court, you immediately go. Don't postpone it. And be truthful and pay your fees on time. Because even Harish Salve said, I charge a reasonable fee, which is fairly high by standard. So lawyer fees you have to pay properly. Thank you very much. And I've got few cases also. I think we are running out of time. So this is the basis of how you go about a medical legal case and how you should interact with your lawyer. Thank you very much.
Thank you, Ashok. Probably we can have 1 or 2 questions also because a lot of people may have their own experience. This couple of things I am reiterating. The initial reply to the notice from the notice from the patient should be very concrete without divulging too much of information. For example, I will tell you one, I have treated VKH syndrome with angiographic diagnosis of VKH, and perfect. Patient had X-ray-RD, hand movements and 1 meter vision, became 6'6" with steroids and all the immunosuppressives and all. So after 6 months, he gave a notice to me saying that after my tablets, he got white patches in the skin. It is vitiligo, right? So it is associated in VKH. So the first reply itself, I was extremely strong. I gave a strong reply. It didn't even go to the court because a common sense man will not do this. So that is one. And the Krishnamar versus State of Tamil Nadu, Dr. Ashok already mentioned. In 1996, there was no guidelines or standard of care for ROP, right? Still, that case was lost miserably, and it was against the government of Tamil Nadu. Actually, government of Tamil Nadu had to give a big amount. So it was lost miserably due to poor representation and poor proceedings in the initial stage. Most probably, nobody might have even gone to the court from the government to represent or give all the evidences. So that is the importance. So when you have to hit hard in the initial stage itself, and then proceed with. So next, thank you, Dr. Any questions? We can, vicarious liability is there.
Yeah, vicarious liability is very important because, you work in a hospital. I mean, the patient accuses you of medical negligence. The patient knows that you are a poor doctor. You can only give this much. So what he will do, he will add the managing director's name and hospital's name also. If it is like that, he can get more compensation. And vicarious liability is an established principle in tort. Like a master is liable for the mistake of his servant. So that is something that holds as far as medical negligence is concerned.
Tort is civil law. Tort is civil law. And consumer protection, all these things comes under civil only, not criminal. So, like this case, this Krishnamar versus State of Tamil Nadu, 1.38 crores, it was divided actually. The government of Tamil Nadu will give this much, the superintendent of the hospital will give, that is Egmore, pediatric, women and child hospital will give. Then the unit chief or the head of the department will give this much, and last the attending doctor. So it was divided at 1.38 crores. So these are all things that happens when you don't defend yourself so I mean strongly in the initial stage itself. So we'll go to the next one, Dr. Anand Vinekar. He will be telling about calculating compensation in medical legal cases and planning professional indemnity in our practice. Very important thing. So over to you, Dr. Anand.
Thank you, Dr. Mahesh and Dr. Ashok, for this opportunity. It's always such a wonderful learning experience. I think we are all learning in this, and I learned much more than I actually new, just preparing for this talk. So as introduced very nicely by Dr. Ashok, he's told you what the general legal principles are. The next question is, and this we probably need to know, why and how courts are calculating the legal compensation that may be against you, your hospital, or your team. And it's important to know that because, as you'll see in some of the landmark cases, that's how we might be able to defend ourselves better. So this is not a legal advice. As mentioned, I have a postgraduate diploma in medical legal law, but I'm certainly not a practicing lawyer, but I've got a lot of help from my teachers at NLS Bangalore. So I think, before the trial actually happens in the court, a lot of it happens in media, and that's where all of us really get stuck as medical professionals. As you can see, this medical negligence kills 50 lakh Indians every year, and these are real newspaper cuttings coming out of different parts of the country. And as Dr. Ashok mentioned, there is this concept of res ipsa loquitur, where the entire onus of the burden of proof falls on us as doctors, leaving a mop inside, a scissor inside. Of course, probably in ophthalmology, we can't leave such large objects inside, but enucleating the wrong eye, for example, is just one example of res ipsa loquitur. And ophthalmology may be slightly lower down in the number of cases this is about 2 calendar years. This is a summer particle. You can see surgery gynae very high, and this is actually true across the world perhaps. But ophthalmology is there. It's fairly significant, and that's why we need to know. He's already clarified this: negligence, unethical, and misconduct. So we're going to only deal about negligence cases. The other two are actually well established in the National Medical Council Code of Ethics, which is currently under abeyance. Duty, dereliction, damage. As Dr. Ashok mentioned, firstly, you have to have a duty of care. So a patient is yours only when he subjects himself or herself to your care. And that duty starts as soon as you accept the patient. If you're a free hospital, the moment the patient walks in and you have sort of even that 10 rupee registration fee, that's your patient. Patient is cured, you transfer, patient dies, hopefully not in case of ophthalmology, that's when it ends. So that's when the duty ends, and this does not apply to emergency cases. Dereliction basically means when something goes wrong. You owed the duty, you did not perform the duty, and as mentioned, you don't have to be the best doctor in your field. You just have to be a reasonably average one, and reasonable average is not something that's defined so much by professional conduct, not if you practice the professional guidelines, but also that you are complying by the legal standards. So you have to be expected to do something, and that acceptance has to be also currently accepted. Now, as the Jacob Matthew case showed, fortunately for us, it's increasingly difficult for a patient to file a criminal case against us, and exceptions will not be discussed in this talk. So mostly we are going to confine ourselves to civil cases or tort cases. And first of all, why do we even need to know how courts calculate the compensation? And that's because, unfortunately, there is no formula. And it falls only on the fact that, yes, there's a lot of arbitrariness that the judges and the law takes. But if you look at literature and if you look at the cases that have come out just in the past 7-8 years, there are two broad principles, although this is not in textbooks, but this is what you can infer from the major judgments. So one is the multiplier method, which basically falls back on the Accident Claim Relief Act, which is basically someone meets with an accident, is either dead or disabled, and how do courts calculate that compensation? And that methodology is used in medical legal negligence. The second one is the just and reasonable principle. And by this we mean, this falls back almost 50 years now, where the Land Reforms Act, when the government of India wanted more socialistic distribution of land, they took from the landlords and they decided to take it off as government land. And then how would you compensate such zamindars? And that was, of course, some of the major constitutional amendments in the first 15 years until Keshavananda Bharati have all been based on that. So knowing the historical perspective is important because this is how the judges would still think. Now, I'm going to use two main cases as learning experiences, and then we can figure out the formula. So, pardon the photograph there. Ashish Chavan versus Indian Air Force. And this is an important case, firstly, because it's the most recent, 2021. And this soldier is now alleging that he became HIV positive because of an infected blood that was given to him. The blood came from the Army hospital, was given to him in the Air Force hospital, and both were held liable. So it was basically against the defense forces. So you can imagine a soldier against Government of India's defense forces. So that's why it's so important. So he claimed 95.31 crores, and because it was more than 2 crores, it went to the National Commission, and this is how he justified it. So if you look at this larger numbers, the numbers are not important, but the principles are 1.5 crores for his traveling expense, 50 lakhs for his medicine, 1.53 for the loss of salary, assuming when he would have retired from government service, and finally the medical expenses that he said could have been used if there were some advances in technology. And now this one here, which is human rights violation, mental agony, defamation, these are called non-pecuniary, as that term has been mentioned already. Pecuniary basically means related to money. Non-pecuniary, not related to money. So we have to be aware of both, and this is how courts will look at it. So now what did the court say? In fact, the court actually ended up giving more salary than what he claimed, but reduced in some other headings, and let's look at that. So this is exactly how a math formula works. This is how much he would have earned into this many months, into that many years left for his retirement, and add a little more because increments, appraisals, 1.6, 40%, these are percentages that are being used. The prosecution said, I mean, this is relevant to the case, that ELISA was not done, you did not check whether the blood was not infected, you didn't even take my consent to give me blood, apparently he had macrocytic anemia, long-standing and so on, and that you took so long to even reply to my judgment, and you've not given me the cases, you did not give me the report when I asked for. And remember, from the government side, the additional solicitor general is fighting. So this is a very high-profile case. And he takes the premise that you're not even a consumer, the same thing that was mentioned. Under the CPA, you don't even come under it because you were given free treatment. You are a soldier, and we gave you free treatment in a government hospital. And that you did not take expert opinion, that you are supposed to claim within 3 years, again mentioned as an exception. You had pre-existing disease. But this is one thing that the defense will always work on, that is novus actus intervenius, which means that the time he got the blood and the time he became HIV positive is almost 7-8 years in between. So we don't know what happened in between. Perhaps you got something else, there was exposure of some other kind. So that is the defense, it was mentioned. But the court, now this is how the court calculated. So all of that will work so much more on the non-pecuniary. But the pecuniary is right out there for all of you to see. The amount of salary, the amount of allowances he already took. He was taking pension, by the way. So they subtracted all of that and they said, okay, minus the pension, minus the personal expenses, minus how much you've already been paid, here's how much is due to you. And including, they added a helper. So they said somebody needs to help you, 12,500 per salary for that, and so on. The mental agony, he also claimed that his wife divorced him because of HIV and therefore put that also. So they added literally 10 lakhs per component. Loss of employment from other recruiters, mental agony for going for different RTIs, divorce, and there was a court of inquiry that the defense took, and he was not even party to that. So 10 lakhs each, 5 points, 50 lakhs. So mental agony, most cases, in other judgments, you'll find it 10 lakhs, but here it was enhanced to 50 lakhs. So this is the non-pecuniary. In addition, they said you have to get free treatment and so on. So just to come back, now this is how the formula is calculated. The next two slides are sort of derived from many judgments. So you have pecuniary, which is expenses related to the current treatment that has already happened. And if you jump, number 3 is future medical expenses. Then in between, you have a 2A and a 2B, which is loss of earning during your treatment, the current treatment, and loss of earning that you may have in your future earnings. That is, that you could have earned, but you can't now because of the disability. Number 4, 5, 6 is damage of pain, which is basically mental trauma, loss of amenities, in this case, loss of marriage, divorce, and the fact that you may not live as long enough in this case, so expectations of life. In our case, a blind child, a blind patient, the inability to enjoy life would come under 0.6. Now, this is the formula that is used. If you have a simple injury or a personal injury, which is not, and we'll define that, the caps are only in 1, 2A, and 4. And just for elaboration, I've relisted them below. And if it's a serious injury, then you also, in addition, have 2B, 3, 5, and 6. So a serious injury is a grievous injury, and we'll define that. And that's when ophthalmologists are concerned. Unfortunately, a lot of it will be grievous injury. And then 1, 2A, 2B, 3, 4, 5, and 6 may be calculated against us. Just and reasonable to say, just and reasonable to say is a little bit of guesswork. It doesn't use the math. These are some sort of defining cases where, but still, one thing that they always calculate is how much salary that you have lost, number 1, and what are the medical expenses that you have incurred. Their principle in these just and reasonable cases is that Latin term there, restitutio integrum, which means how much money will it take to get you back to being as good as you were before the damage happened on you. So that's the rough principle that is used. And it should not be that much that he should have won a lottery, but it shouldn't be so little that it is just nominal. So that's the difference between the windfall and a pittance. And it has to be based on the proven income. You cannot say that this child will grow up and he will earn $1 million per year, and so let's compensate him for that. It is the actual amount. And for that, again, this has been mentioned time again. This is an ROP case, Krishna Kumar, where the child was blind for life. So this is not dead. So when not dead means at the time of the damage, which is blindness, when the child was a few months old, the child did not have an income. So therefore, to use this formula of current income and future income was not possible. And therefore, this is how that was calculated. Expenses already undertaken by the parents, the pain and suffering, especially of the mother as well, that was added. Lost wages of the mother, because she did not work for about that many years taking care of it, and future care, plus inflation. So this is how that 1.38 plus interest was calculated. For 20 years, the treatment, because the case dragged on for that long, hardship to mother, the current age, life expectancy for all these court cases is taken as 70 years. And the monthly expenses, therefore, into 51 years plus inflation. So that's how it became 1.38 plus the interest they had paid, eventually ended up paying 1.8 crores. Does anyone know what the largest compensation in medical legal history is? Well, it's 6.8 crores, and it's a hospital stone throw away from here. Right, it's in Calcutta, but actually the amount finally paid out was 11.3 crores because interest was added from the time of the damage till the time the patient won the case in the Supreme Court. So this has gone to the Supreme Court. So why is it such a large compensation? Because that person who died was a US national. She was an Indian origin. She was doing her graduation there. She was a doctor by profession. She was doing her graduation, and she died because of, let's not get into the details of the case. And this is how the prosecution calculated. They said that this is how much she could have earned. She would have earned $5.1 million, and then they gave some evidence, but the court said no. As a graduate student, she was getting a compensation of $30,000. Let's say she was going to now earn $40,000 from the following year. They added that to 30%, deducted it from the personal expenses, and unfortunately what went against the hospital was the fact that a dollar at that time was 54 rupees. Today, I believe it's 84, so that's already gone up so much more. This is from the judgment itself, what the prosecution claimed and what the defense said, and finally what the court gave. And this is what somebody asked, vicarious liability. So the hospital was charged 5.8 crores out of that, and 10 lakhs from one doctor, 10 lakhs from the other doctor, and 5 lakhs from the third person. So literally the 99, 95, 98% goes from the hospital, and the doctors end up paying a little less. Nevertheless, this is a very, very large claim. So the Supreme Court has actually put down these norms on medical negligence, reasonable level of skill, reasonable level of care, and that, so it's not, often these cases, when they're put against you, as mentioned already, if your defense is good, most of the time you will be fine. And we are probably waiting for this to happen. As mentioned, it is still not taken off. We are still liable under 304A, under the new law, but it's probably reduced to 2 years. So what are the legal principles? The burden of proof in medical legal lies with the respondents, right? So, and not the appellants, which is basically us. And the damages in theory have no limit. So after I've given you these two formulas, if they have a very good lawyer, they can actually claim more, but you know you're restricted by pecuniary and non-pecuniary. And you can only claim for what will eventually result from what you have done. So, eye injury, suddenly now the leg has a problem, or as Dr. Mahesh mentioned, vitiligo because of VKH, that will not be a cause of what your treatment has performed. And finally, you will therefore be, these are the defenses that you will have, that you will be liable only to the extent of your action. Now, I'm also asked to cover medical indemnity. I just have 2 slides on that. As already mentioned, a lot of the schemes cover it. So, 2 things here, 2 principles. The amount is up to you. Whatever you can afford, the higher you can afford, the better. But there are 2 principles. If you're working in a group, in a team, in a hospital, where a lot of people report to you, whether it's a patient care attendant or a technician going out in the outreach, doing your work, you must cover for them as well. And if you talk to your insurance provider, with a small increase in premium, you will be able to cover for them as well. And examples are given here. And this is called the error of omission policy, where if there is an omission or an act of commission done by some of your subordinates who are not in the medical profession, they can also be covered under your policy. And the second principle of medical indemnity is, let's say you have a policy of 50 lakhs. We urge you to take more, but 50 lakhs is what this example is. Then divide divide it into 2 policies and probably into 2 of the schemes. So break it up as 20 and 30 lakhs. This is assumed to be a better fiscal way of doing it than taking one. Now, finally, I'm just going to say that our safeguards against medical legal negligence is to follow reasonable care and skill. This basically means for us, follow what is the preferred practice guideline. Keep great records, keep it at least till the government happens. In cases of ROP that we deal with, you have to keep it for 3 years after the patient turns an adult. So, because that's how long they can file. Till the age of 21, they can file a case against you. And interpersonal skills, and finally, last point is medical indemnity. Yeah, thank you so much.
Thank you, Dr. Anand. It was a wonderful talk. Now I invite Dr. Mahesh for his talk on 10 classic verdicts that every ophthalmologist should know. Dr. Mahesh.
Thank you, Ashok. I will be speaking about some of the verdicts that all of us should know. Why we should know? When we talk about ophthalmology, we talk about studies. We talk about research and studies, and we quote that everywhere. Anchor study, Marina study, this study, that study. Based on that, we do this. So, like that, in law also, there is something called verdicts of highest court, like Supreme Court and High Court and everything. So, which is binding to other courts also. So, that is why we should know some of the verdicts, and then based on that, we can always argue in our favor. So, this is called judge-made law. Unfortunately, nothing much is there in the constitution or law regarding the medical negligences. So, it is called judge-made law or stare decisis. So, what that means is, if the Supreme Court gives a verdict, that is binding. That can be quoted by us in the lower court to defend us. So, it is based on Article 141 and 142. Whatever the Supreme Court says will be binding to the lower court. So, it is called judge-made law, depending on individual cases. So, this is as good as a law, if we can quote it properly. So, what we do, PubMed search, like that we can do literature search from, probably. There are different things, I think. I use India Canon, very easy. And search words. For example, I put end ophthalmitis and medico legal. I get 1,500 citations. Full verdict. You will get the full verdict of all the details. So, in that you can probably choose, like in PubMed we give specific topics. Like, so we limited the search by High Court and Supreme Court verdicts. Then you will get only that. And you can use that, go through that, and defend yourself in your case. So, few things that I have to tell you is starting from Bolam test. Okay, this is not Indian court, but Bolam test is the one that is being applied across India in medical negligences. What is Bolam test? In 1957, there was a case between Bolam versus Fry and Barnett Hospital Management. I think they had a spinal injury following a cyst removal, and patient had a paralysis or something. But they took evidence from the other doctors, and they said all of us will do the same thing. So this is a rare complication. So he was let off. The doctor was let off, and this remains the principal test to assess standard of care. So in Bolam test, there should be a normal practice guideline. That is, for example, we manage end ophthalmitis. There is a standard guideline. And secondly, it has to be proven that defender has not adopted that practice. That means you have not given intravitreal injection, you have not given something else. Third, that the doctor has taken a path which no doctor will actually take. That is, probably you have not attended the patient for 2 days, 3 days. So these three things are part of testing, applying Bolam test in your case. So like this, I told you, AC tap, intravitreal injection, vitrectomy, systemic, all these things are part of the standard of care. Suppose the doctor has not attended, or doctor has given a not given intravital injection or something like that, or doctor has thought that it is a inflammation and given only steroids, something like that. So these things will go against the standard of care. Now, second one, already discussed, criminal proceedings against the doctors are usually difficult to take except in death, which is quite rare in our cases, but we do have, there are a lot of cases where death has happened after general anesthesia complications in ophthalmic setup also. Usually the court says there should be a mens rea, that is a guilty mind should be there when you charge a criminal negligence. So no doctor will ever think about screwing their patient's eye. So there is no criminal negligence in any of these cases. So in death, this comes to play. So in Jacob Matthew versus State of Punjab, which is quoted everywhere, because that case has defined what is medical negligence and what should be the requisites for charging criminal negligence, like severe disdain or druglessness, drugless disregard for the safety of others. This should be there. But is it that what is happening now? For example, real life scenarios in a death or a cluster endophthalmitis, there are different factors working here. Here are the police, politicians, and media. I call it the dirty three. They can charge they can go out of the way to trouble you and causes considerable pain to the healthcare providers. Probably Bharatiya Nyaya Samhita may have some other things. I have not gone through. Ashok was telling it is not something great beyond IPC. So anyway, the police can arrest you based on the complaints, and media can come and if you are arrested on a Friday night, you will be there at least for 48 hours within the police station before getting bail. So these things are happening. Even there was a suicide of a lady, Archana, in Rajasthan after the death of a gynecologist. So these things are happening because the politicians and media play a dirty role in these cases. So what is, ultimately nothing will happen in the court of law, but the pain that gives in this real life scenario is very difficult. Now regarding consent, very important. This Samira Kohli versus Prabha Manchanda case in 2008 has defined what should be the consent. It should be a legally valid consent, not, there are different types of consent. In UK it is real consent, in US it is informed consent, where everything should be mentioned. It should be like a book. In India it is called legally valid consent given by the person, expressed consent, that is actually ideally it should be written by the patient freely and voluntarily without fear, signed by doctor, patient and witnesses. And ideally it should be written in patient's own handwriting. None of us do that. We take something called blanket consent. Ideally the consent is the major source of losing a medical legal case. This study was done from Korea. In fact, they took all the medical legal cases that they lost, and it was mentioned that more than 50%, more than half the cases were decided in favor of the plaintiff due to the violation of informed consent. That is the importance of informed consent. AIOS has brought out informed consent booklet that all of us can customize. I am again telling, don't copy and just paste. You can customize it based on your this thing. This covers everything. You may not need everything in your scenario, so you can customize in your own language. And you should make the patient write at the end of the consent, I have understood in local language. I have understood, I have read and understood. That one line at least should be there, because it is very difficult for them to write the whole thing again. So that is regarding consent. And one more thing in that that I will come to. CAM cases are, they also need consent. It is not blanket consent. That is not blanket consent like filling the blanks. No, it is not at all valid. There are plenty of cases across India where court has mentioned blanket consent is not valid. Going back to the fourth verdict, that is off-label medications. We use a lot of off-label medications, triamcinolone, TPA, antibiotics, various intravital antibiotics. These are all not ideally made for ophthalmic use. But Avastin has been used over the last few years, And there are cases for and against Avastin, for and against doctors in the Avastin cases. For example, this case in 2019, post-Avastin endophthalmitis, and they applied Bolam test, and all the management was proper, that immediate management, everything was proper. So court concurred no negligence. But in the other case in 2018, this case, Telangana State Consumer Redressal Forum has clearly mentioned that the use of off-label medicines in India. In India, it is illegal to use any drugs for anything else other than what it has been approved by DCGI. Now, this is important judgment, and the scenario 5-6 years back was little different from the scenario now. When there is no other alternative, you can use, because you have to use. Like intravitreal antibiotics in endophthalmitis, nobody has made an antibiotic only for intravitreal injection. It is all parenteral use only, vancomycin, ceftazidime. So you can use. But now this has to be taken care of when we use Avastin. So VRSA, AIOS guidelines are there, uniform consent, all this. And here there is an important point which is different from the last 5 years back when the Avastin ban and all these things were happening. There are alternatives to Avastin which are approved. Okay, now biosimilars are there which are approved for the condition, which are cheap enough. So at present, it is little dangerous. I am not telling don't use Avastin, but it is little dangerous on a medico-legal point of view to use Avastin. So learnings, these are the learnings from this case. Now, ROP, the case 5 is ROP, already discussed, Krishnamar versus State of Tamil Nadu. It was a badly contested case from beginning, and probably due to the inefficient state machinery, and they had to give a compensation of 1.38 crores. So learnings from the case, be aware of the latest guidelines. What is the ROP guidelines? Here nobody has given a case, because I didn't get vision, it is because they didn't screen in time, it was not detected. That is the medical negligence. Not after your laser or vitreous surgery, they have not got vision. You have tried maximum, that is the result. So never miss a screening, proper screening in ROP. And the another important point here, again I am coming, is government doctors are not immune to CPA. ROP babies, already Ashok mentioned, ROP babies can sue even after 18 years. So law of limitation is applied after 18 years. Up to 21 years they can sue. So these things are important in learnings from this. Compensation already Dr. Anand has. Now coming to camp surgeries. This is one case where it was in 2012. Basically, the patient had got an endophthalmitis. And the court very clearly said camp does not mean compensation can be reduced, because ideally free treatment means free for everyone and everything in the hospital. That means suppose you do camp cases for 30 cases and you charge little from one patient, you charge 4 in IOL, you charge little, or even registration in the hospital, you charge something. Why in government hospital it is, they come under CPA? Because they charge 10 rupees for a registration in the OPD. It is not free treatment. So complete free treatment only is exempt from the Consumer Protection Act. So don't think that camp is not, it also comes under this. So that is one point that I wanted to. Then the next point is case number 7. Bad outcome are not doctor's fault if managed properly. This is an important message. Like this case, Supreme Court has told that after sterilization, sometimes it fails. So it is doctors is not at fault, because the failure rate is almost there. So when you give a consent, you can mention the rare complications of 5%, 2%, endophthalmitis, all these things. So you have told the patient. So this is important. The bad outcome is not. These are some of the points that we can use for defending ourselves. Like this, another, Sachin Tyagi versus National Consumer Redressal Forum. There was a scleral melt after cataract surgery. Who can predict scleral melt? It is an immunological thing. He has done everything in under possible with consultation, other cross consultations, everything. And Consumer Court finally said, this is a rare complication, and he has done everything possible. So they ruled out. Unrealistic demand for compensation should not be allowed. This is another verdict from National Consumer Redressal Forum. In fact, I was talking to, this is a Saini versus Center for Sight. The patient asked for 6 crores on various grounds. including this is a refractive surgery, and that is another problem now a lot of people are facing. So they ask 6 crores plus for related to treatment, loss of earnings, future medical expense, damage for pain, suffering, loss of marriage prospects, etc., etc. So ultimately, the court concluded that the claims for compensations were exaggerated and lacked basis, and there is an increasing tendency among complainants to overvalue their claims in consumer. So they just dismissed it and asked the patient, if you want, you can go to the lower court and apply for a smaller amount. So that is what. So these are some of the interesting cases that has come over the last few years. Differences in opinion among doctors is not negligence. That is another important thing. Suppose I treat a patient based on, Dr. Ashok will explain probably, that if there is a case of CSCR with X-rative RD, it may be mistaken for VKH sometimes because the findings are, and the treatment is opposite. So there could be, like Kusum Sharma versus Batra Hospital, there was a case. In that, the court has clearly mentioned there could be a difference of opinion in the differential diagnosis and management protocol. So it doesn't mean that doctor is negligent. And medical professionals should not be unnecessarily harassed or humiliated so that they can perform the professional duties without fear. So this verdict also we can use whenever we need. This is a Supreme Court judgment. Endophthalmitis, the last but not the least, it is the biggest nightmare we can have, because this is the only place where it is little difficult to defend ourselves. Because if you get a cluster endophthalmitis, there was a session by Vision 2020 yesterday, cluster endophthalmitis, even though it is from the fluid, only the doctor is taken, the fluid I use, ringer lactate I used from one company, they are not there in the picture, only the doctor is charged. So there are different cases. And in fact, I searched in the endophthalmitis cases, I got around 50 cases from the Supreme Court level, National Consumer Redressal. 98% of cases are in favor of doctors. Only 2% are lost because of something happening wrong in the documentation or something like that, or mismanagement or delay in treatment like that. So this is the good news that all of us should think about, that 98% of endophthalmitis court in Supreme Court is in favor of, even though the lower court might have said differently. So like this is a case, National Consumer Redressal Forum, and they mentions that this is an inherent risk associated with cataract surgery and the management is okay, so they let the doctor go. And this is another case. This is a postoperative, if the postoperative care is standard, there is no point in penalizing the doctor. But there is other extreme also where the court has gone against the doctor. Like this case was there. The patient was kept without doing any intravitreal or anything for 3 days, and then patient was referred. So that delay in referral of 3 days created, and it was awarded against the doctor. So this is one thing. Like another one, diabetes control in before cataract surgery. The doctor knew that the diabetes was there, but he never bothered to check it or control it. This is a little controversial. What is the ideal guideline? There is nothing like that. But even there was no checking of sugar, blood sugar or anything. So it was against the doctor. So this is another one. Actual vision was not recorded. Findings were not recorded. Because of all these things, there was a compensation of 1 lakh against the doctor. So in endophthalmitis, it can go either way. But 98% are in favor of doctors. So with that, these are around 10 verdicts that I took from the site, and probably some of them may be useful when you defend yourself in the court of law. We have 15 more minutes. Any questions? We are ready to discuss. Thank you.
One comment, okay. You can use the mics.
In case of probable fungal endophthalmitis, the patient may have diminution of vision after 3 weeks or so. So, how the doctor who has given good vision or reasonably good vision for the 2 weeks or 3 weeks post-op can be held reliable.
It is from the time of diagnosis of ENDOF. Like, after 3 weeks he comes with ENDOF. Immediately after diagnosis, you have to take appropriate treatment.
What he is asking is whether we can defend it because it is
Now,
from
the
some
patient post-operatively was okay.
Yeah.
For about nearly up to 3 weeks,
There was
the
no
patient didn't complain any diminution of vision. After 3 weeks, there was a complaint of diminution of vision, and it may be referred to some other places, and ultimately the eye may or may not be lost. It is not known to the primary operating doctor. But in these cases, how the primary operating doctor can be held liable in the case.
Okay, your defenses I will tell you. One, this has come after 3 weeks. So it might have been, you can give all the, when you defend yourself, when you can give all the that sterilization protocols, other people done in that time, none of them had got any endophthalmitis. The record of all the other people, and if you have a standard theater protocols like NABH, all this can be submitted to the court at the initial stage itself, saying that this has not come from myself. This is for defending, I am telling you. The number 2 is, once you diagnose it, whether you have given, instituted proper intravitreal AC tab, that is the second part of management of the complication. Okay, so these two, yeah.
In most of the doctors who are not very conversant with the posterior segment formalities, they refer the case to some
Exactly,
other
fine,
vitreoretinal
that is
surgeon.
enough, that is enough.
So the primary doctor just referred the case with suspicion of something for vitreoretinal checkup and do the needful. In these cases, the patient may not go to the doctor.
That is his, then that is...
The patient may go to the doctor after unreasonable delay. Or that doctor may not be doing something good. Or even the doctor has done as per protocol, the outcome may not be good.
Yeah, I know.
Say after one year or 6 months, the patient files a case against the primary doctor only.
Agree, sir. Actually, in this case, it is very easy to defend your case. If I was your lawyer, I can easily defend. All these points can be used. Yes. Because
It should be documented that you have referred on the proper time.
Anybody can give any case for anything.
Yes.
So, because he
The
has,
right of the patient
but,
to give a case.
You will not lose the case. That is for sure.
The
if
thing is
properly.
that on the first instance, where there was a doubt that something may occur in the posterior segment, and I am not conversant very well and confident to tackle in my...
No, then it doesn't become your liability because you have already referred, so you don't have to worry. And a person can give a case against anybody. You cannot prevent somebody from giving a case. When a case
So
comes,
if
you
there
have to
is-
prove yourself and get out of it. That is it.
If the referral note is there,
Yeah.
the primary doctor is saved.
Yeah, it is saved actually. If you have all the other
Documentation and everything,
documentation
you are
of
saved.
all these things, that you are, that is very difficult. I told you, 98% of ENDOF properly managed. Here the proper management is you have referred immediately on the suspicion of an endophthalmitis because there is no facility in it. That is enough. That is enough. You have immediately.
The
Whether you have
complications
gone-
can happen to anybody, but it should be properly managed. If you can document that, that is enough.
In many cases, the patient doesn't come to the follow-up at proper time.
Exactly.
Or
That-
designated time, number 1. Number 2, I have seen so many patients at their residence, they use very unhygienic atmosphere and put the drops anywhere on the table and instead of the 4 times or 8 times, they put once. So how this thing can be proved in court, that the patient himself is careless?
Yeah, your only defense is what you have recorded. Suppose patient did not come for a follow-up 1 week later and he has come after 2-3 weeks. Just record it. Patient has not come for follow-up in spite of this thing. That record is enough for you to save you. Okay, so that is...
Acha. In some instances, there are some doctors who send their assistant to the nearby patients at their residence for the dressing at their residence after one day or 2 or 3 days consecutively. Is it
it is not.
accepted by law?
It is not accepted.
Very
If there is an
difficult to
endorphin, it is not accepted.
No.
It will be, doctor will be held liable because he has to see the patient next day, he has not seen. That is negligence, no?
Oh, the
Yeah,
next.
now, this goes to court. Let us imagine that this has gone to the court. The court will ask an expert opinion. For example, the head of the department of medical college or RP center, somebody will be called. And they will ask, what is the standard of practice? Whether you will see the patient next day. And the expert opinion will be that we have to see the next day, right? So if somebody has gone into the house for dressing after 3 days, you cannot stand. You will lose.
You lose.
So that is the importance of
Following protocols.
following
So
standard
for
protocol.
for the daycare cataract surgery,
Yeah.
they don't come to the hospital or
No, that is what I said, no, we have to record. We have to record and make sure that it's a patient's
No,
fault and that can be
yeah.
said. That is all.
Sir.
Sir, you have front door.
It's on.
We have taken all the care for pre-operative assessments, patient is stable, cardiac-wise, everything. And MI happens, on table. Once in a while, this scenario happens. And, the anesthetist is not always there, especially with, those topical cataracts. And we don't need anybody else than our trained staff of ours. Now, we are not good enough to manage that case there and then on the table. If something bad happens, the patient can't revive the patient and, the most unwanted of the things happen, where does the doctor's responsibility stand in these cases, sir?
Actually, the doctor will be held liable because at least, if you are you have to keep an anesthetist and at least the basic care you are supposed to give so that the patient at least can be shifted to a hospital where he can get an expert care.
Sir, this has happened in our hospital at least 2 or 3 times. There was death on table after cataract surgery. There was an anesthetist who tried everything, gave all these things and recorded, and then even intubated and shifted the patient to the nearest super specialty hospital with no time. But if you don't have an anesthetist,
that is the
it
thing,
is little
sir.
difficult to this thing. I agree.
And these days, getting anesthetic as standby is a thing, sir. Like especially in standalone hospitals, where, you just basically are a cataract surgeon and that's all you do. 2, 3, 4 surgeries, the anesthetic is almost never ever available. And if it's a complicated case, we definitely want somebody to be there. But, the routine ones, it's not there. And, this scenario happens once in a while,
It
sir,
is
for
better
sure.
to have an anesthetist.
This has happened even in bigger hospitals where there is a death and it's very difficult to defend in spite of having everything. So if there is no anesthetist, it will be difficult to defend, sir.
Yeah, okay.
And now we are talking about the Bolam test where, suppose you do some procedures, some standard of care you follow, and some other doctor comes and says that this is what I also do. So that means according to Bolam test, the court will feel that is a standard of care. But now we are going from Bolam to Bolito's test. There is something called as the Bolito's test where it is not only enough that some other doctor should say that this is the standard of care, it should be supported by evidence in literature. See, I have my doctor friend. You do something else. I also keep my scissors inside the uterus and suture. Not only he, I also do. So that doesn't become standard of care. So there should be some evidence also to show that, some literature evidence also show that that is standard. So slowly, in Consumer Protection Court, it is going from Bolam to Bolito's test. So that is something which we have to keep in mind.
That means, in other words, the court is not listening to the expert witness alone. They will think independently and decide.
It is only a corroborative evidence. The court has to finally decide.
Yes, sir.
Sir, regarding the consent form you said, we cannot fill in the blanks. But most of the hospitals have pre-filled forms. So at the end, you said we should make them write in their own languages.
Yeah.
The last point, last line.
Yeah, actually, this is not foolproof, but it is better than a blanket consent. So you can ask them to write in their own language, I have read all these things and understood and give full consent. One line.
Okay.
If the patient cannot read and write, somebody has read it and I understand everything.
Because most of the consent, this line also is typed.
Yeah.
And they just sign it.
And
I think, you can't write the 2-3 pages In VR surgery, we, in some places, we also take a one-page consent that if oil is put, it has to be removed, cataract comes, it has to be removed. Major things we explain, in the standard, they write, by
And
standard write.
is there a need for a second opinion in case of evisceration and enucleation?
Yes, two people should see better.
Which one?
Evisceration, no PLI,
Evisceration,
evisceration,
yeah.
enucleation.
Ideally, yeah.
Another thing is, you can take a video consent. See, the importance of video consent is one-night patient. So you call the relatives and the patient and you say that, do you consent to take a video consent? And should be recorded. Patient says yes. And then you explain everything to the patient. And you ask the patient whether you agree to all this and record it and give it to your, who are assistants so that it can be kept in a soft copy. What importance was that, I had a one-night patient who had an RD. He's an old man. So consent, everything written. Then I called the patient and talked. I said, what is your name? He said some name. He is around a very old man. Then I asked him, what is your age? He said, I'm 30 years old. So actually he was an Alzheimer's patient basically. He did not even know what he was saying. Now suppose you are taken a consent. Something happens tomorrow, he will go to court and say, who are you? He will say, I'm Abraham Lincoln. Then what is the point? So you're in big soup, no? So whenever you're in doubt, better you take a video consent. That gives you, some additional advantage over all this.
There is a small group whom we cannot take consent, like not conscious or coma or not comprehending what we are telling, and less than 12 years. So these cases you need a responsible guardian with two people.
And emergency cases, that doesn't apply for us. The patient
Emergency,
is
anything is possible. Emergency
consent,
without, like road traffic accident, somebody has given, come with a head injury and a
cannot wait for a
perforating
consent to
injury.
treat the patient.
You don't even know who is the patient. Everything, the police, you have to inform and then you can.
The most important thing in endophthalmitis cases is there was one case from Jipmer. Why they lost it was, it was not recorded that pre-op apidin was, or povidone iodine was not put for, it was not documented. So easily they could prove that all necessary precautions to prevent an end-off has not been taken. So that is enough to show. In fact, they got a favorable medical report from both LVP and SN saying that the doctor was right. But they could easily, he got an opinion from some other doctor who clearly said that povidone iodine has not been put. It is not recorded. So these are the important things,
In cataract surgery and all, the standard protocol, you can even keep it
Right, but they are
the
putting or
OT
not.
notes and all. So that it is copied. Sir,
8:30 time.
9:45. Yes. He wants to get us out. Yeah.
Okay, then I think let's wind up. Thank you
Yeah.
very much
Thank you
for
very much,
coming and for your patient listening.